So by way of an introduction, my name's Alex Saunders. I'm a partner with a firm of solicitors in Norwich called Leathes Prior. And as John has alluded to, amongst other things, and I do other sort of things in the corporate and commercial world, but one of the things that I've decided to specialise in for my sins is data protection, which I think when I first trained with the firm and decided that I was going to specialise in data protection, it was quite an easy tick box because this was pre-GDPR, when data protection wasn't really the same sort of issue as it was, and sort of it's been a good and a bad thing in the sense that I've very much been thrust into the spotlight with the advent of the GDPR, but at the same time it's meant my workload's about 3 times as busy. So a good and a bad thing, but the thing I'm here to speak with everyone about is myth busting. Because the GDPR, probably more so than any area of law that I've come across, is one of the areas that touches on most, if not all, organisations, and is sort of overwhelmingly misunderstood. And there were lots and lots of myths out there. There was a lot of misinformation that came about when the GDPR first came into force back in 2018. And there was also a lot of hype. And I remember my local newspaper running the story just before May 2018, when all of this kicked in, saying, is GDPR bigger than Brexit? And I seem to remember thinking at the time, that's not the most ridiculous headline I've ever seen. But I think in hindsight, it's probably sort of somewhat overhyped, but it gives you an idea of the portrayal in the media that this bit of legislation was getting. And although that hype has largely died down, thankfully, it is still relevant. It is still something that all organisations on this call will need to comply with. And the consequences of failing to do so are potentially significant. They're not quite as bad, and we'll see a bit later on, they're not quite as bad as some may think, but they are potentially quite significant. So what I'm here to do today is to try and address as many of those sort of myths, as many of those items of misinformation that I possibly can, hopefully answer some of the questions. Off the bat, the DPO one is particularly interesting because there's a lot of confusion around that area, and hopefully some of the information I'll deliver to you today will give you some comfort. So we're going to look at that, and we're going to focus on 5 common myths. But where this talk is going to differ from the one that I delivered at Scribe Fest is that we're going to focus a bit more on Q&A. So I kind of, at the end, will want to hear what everyone on this call has to say, what their sort of big questions are, what some of the biggest misunderstandings are that they've come across, and I will do my utmost to help where I possibly can. So I don't want to labour on this point too much, but I do just want to have a quick recap on what the UK GDPR actually is. I'm sure you're all familiar with it, at least as a concept. So the UK GDPR, which is the terminology I'll use today, is just the UK version of the GDPR. Other than small technical references, it is identical to the European legislation that came into force back in May 2018. Most crucially, the GDPR governs the use of personal data. And that's really the crux of it. If it's not personal data, the GDPR doesn't apply, and all of the things that I'm going to be talking to you about fall away. But where personal data does apply, then you need to consider the rules that are set out under the GDPR. And personal data effectively is anything that identifies a living individual. So that can be a name, it can be an email address, it can be a telephone number, even an IP address can potentially be personal data. But crucially, and I think this is going to be relevant for those of you on the call, and it sounds rather morbid, but information relating to those who are deceased. So that might be relevant, for example, administering crematorium records, things like that, is not considered personal data. The data of deceased voting records relating to deceased individuals will not constitute personal data. And where it's not personal data, this doesn't apply. The Freedom of Information Act might still apply, but the GDPR doesn't. So it applies to all organisations operating within the UK and non-UK organisations who are offering goods and services in the UK. So ultimately the upshot of that is that it will apply, I suspect, to all organisations that are on this call. And it's enforced by the Information Commissioner's Office, the ICO, who we'll be talking about a bit later on. And then finally, I get this question, even now I get this question an awful lot. I get clients ring me up and say, oh, that whole GDPR thing, presumably that doesn't apply because of Brexit, and we've left the European Union, and the GDPR was EU legislation. And I suppose on my busier days, I sort of wish that would be the case. It would make for a rather short presentation if that was so. Ultimately, the UK GDPR is just the UK version, the domestic version of the GDPR. It's sort of been dropped into UK law, UK domestic law. There are increasing murmurings around potentially deviating from some of the rules under the GDPR. And government ministers have been sort of making a few noises over the last 3 or 4 months, but for various reasons that I won't bore you with today, I suspect that's likely to be more of a mid-term scenario rather than a short-term scenario, not least because of the terms of the withdrawal agreement with the EU would make deviating from the GDPR quite tricky, and it would also make the data flow to organisations in other EU countries quite tricky. So the reality is that the UK GDPR is here to stay, at least in the short term. So let's start with a bit of myth busting and looking at making sure that some of these myths that float around under the GDPR are dispelled and addressed properly. So the first myth, and this is by far and away the biggest area of confusion that I came across, certainly when the GDPR first came into force. I think it's died down slightly, but it's that consent, or someone's permission, is always necessary to use their personal information. That you always need to go out and get someone's permission or someone's consent to use their personal data. It probably won't surprise you when I say that that is absolutely not true. And the reality is that consent is one way to comply with the UK GDPR, but it is not the only way. And in actual fact, it is probably likely to be relied on, consent is likely to be relied on in fairly rare circumstances. It's quite uncommon that I would advise a client to rely on getting someone's permission or getting someone's consent. So in actual fact, consent is one of 6 ways that you can use personal data. And it's important to kind of just set that out as a framework early on. Under the GDPR, there are 6 categories basically where you can lawfully use someone's information. And whenever you use someone's personal information in whatever you're doing within your organization, you need to be able to bring it back and peg it to one of these 6 categories or one of these 6 grounds. Consent is one of them, but it's not the only one. And there are 5 others, most of which are going to be more suitable for what you're doing. And the reason I'm sort of trying to get across that consent is not particularly appropriate in most situations is because the UK GDPR sets a really high standard for getting consent. It's actually quite difficult to get valid consent under the GDPR. Consent under the GDPR needs to be informed, it needs to be clear, it needs to be unambiguous, it needs to be freely given, and it needs to be given by some kind of positive affirmation, some kind of positive step. So there are a number of different tick boxes that you need to comply with in order to get valid consent under the UK GDPR. The most crucial one of those is this concept of consent being freely given. And consent means that individuals, and it really does in this case mean that individuals need to have a real choice and a real control over what consent that they give. And if they don't have real choice and they don't have real control over that giving of consent, then it will not be valid under the GDPR. And there are lots and lots of examples of that being the case. So if, for example, you decided to make the very wise decision to instruct Leathes Prior on a matter, and we would normally engage you as a client with a letter of engagement, what we could not do is within that letter of engagement say, okay, fine, you will, you want to instruct us to provide these legal services. And within that letter of engagement say, oh, and by the way, you consent to us adding you to our marketing list. Because that consent is bundled in with something else and it hasn't been separated, that wouldn't be valid consent under the GDPR. It would be considered not freely given because someone can't separate out the legal services and the giving of consent for marketing. So organisations need to be really conscious of that fact, and where consent is being obtained, hitting those standards. And that's why I suspect in most cases consent isn't going to be necessary for the things that you want or need. And I'll drill down on that in a bit more detail momentarily. So as I've mentioned a few times, consent's only appropriate where there's other grounds that don't apply. So let's talk about what other grounds might be appropriate. I'm going to focus on sort of the three main ones, and the three ones I suspect most of what you do will fall within one of these three categories. So the first one is where you have a contract with an individual, and depending on the size of the organisation, size of the council that you're a part of, it's entirely possible that you employ individuals. So having a contract with an individual is one of the key grounds. So where you have a contract with an individual and you need to use their personal information under that contract, you do not need to get consent to use their personal information. That's an entirely separate ground, and I would never advise that you get consent to use personal information. So to use an example, if I order something on Amazon, which I'm sure lots of you are doing at the moment, what Amazon don't do, and I put in my delivery address, I've then got a contract with Amazon. What Amazon don't do is say, oh, and can we have your consent to use your delivery address to send you this item? Because they have a contract with me that necessitates them needing to use my personal information. The same is true with an employment contract. If you have employees, you should not be asking for their consent really to do anything with their personal data, because in all likelihood, you need to use that personal information under the employment contract with them. So if you to pay them, to carry out grievance, disciplinary, performance reviews, all of those sorts of things, you need that personal data. So you should not be getting consent from employees for these purposes. And the guidance is pretty clear that actually says consent from employees is very unlikely to be valid because it can't be freely given, because an employee probably doesn't have, because there's an imbalance of bargaining powers, an employee doesn't have the ability really to say no to things. So it's not going to be an appropriate ground. This second one is going to be probably the most relevant for everyone on this call, which is that if you need personal information to carry out a public task, or if you need personal information to carry out a task in the public interest, you are entitled to do so without consent. For example, if you're administering waste collection schemes or parking schemes or something like that, something that you either need to do as a matter of a public task, or you need to do it where there is a need in the public interest, you can rely on this public task ground and you don't need to get consent. So that's one that's probably going to relate to a lot of local authorities on this call. And then finally, we have legitimate interest, and legitimate interest is a funny one because effectively it's the catch-all ground. It's the one that will apply if you can't peg your processing, your use of personal data to any other ground. And what effectively legitimate interest means is that the organisation has a legitimate interest to use personal information in whatever they're doing. The caveat to that is that if the individual's own privacy impact is greater than the organisation's legitimate interest, then you would not be able to use the personal information under this ground. So legitimate interest is one where if you look at the list and think, okay, I can't really get consent here, I don't have a contract with the individual, this isn't a public task, legitimate interest is going to be undoubtedly the one you're going to want to look at. But you also always, when you're considering whether you do or don't have a legitimate interest, you need to consider what the privacy impact on the individual actually is. and then it just becomes ultimately a balancing act. And in my experience, and I've, as I'm sure you can imagine, done lots and lots and lots of these balancing exercises, very rarely does the individual's privacy impact outweigh the legitimate interest that the organisation has. So if I give you a practical example of that, a good one to do this is CCTV. And CCTV is almost always going to be a legitimate interest. So if you have premises, car parking spaces, etc., and you want to protect the security and the safety of that area and the people who go within that area, you may want to put up CCTV cameras. In doing that, you would have a legitimate interest to protect the safety and security of people and property. Very, very clear cut. All of the guidance supports that. What you could not do is put CCTVs in an area where there is a reasonable expectation of privacy. So an example of that would be putting it in toilets. I would strongly recommend to everyone on this call that you seriously don't consider doing that. Or if you put it within a reception area, for example, where there's just one person operating, and you're just effectively, surveillancing them for the, for each day. That's where you might have a problem with having a legitimate interest. But in most scenarios, that would be a legitimate interest. And it's a very, very useful basis upon which you can use personal information. As a side note, the GDPR actually within the legislation itself makes it clear that direct marketing can be a legitimate interest. So I suspect there may be questions about that at the end, which I can pick up on. But as a starting point, direct marketing using personal information can be a legitimate interest, and that's actually within the GDPR text itself. So, as a summary on this point, if you are thinking I'm going to include a consent box to get someone to tick to say we can use their personal information, or get them to sign a consent form to say we can use their personal information, I would urge you to think as to whether or not you can rely on one of these other grounds or one of these other criteria, because I suspect 9 times out of 10 you will be able to. So to dispel that myth, consent is not always necessary under the UK GDPR to use personal information. So the second myth that I want to bust, and perhaps not quite as big a myth, but one that's massively misunderstood, is around data breaches. And I noticed when John did his poll earlier and it popped up, there were at least a couple of you who have suffered or had to report data breaches. And it'll be interesting to see what your views are after we chat through this next step. So the myth is that all data breaches need to be reported, and that is an absolute requirement, regardless of the nature or the gravity of the breach. Probably won't surprise you, and we'll get into a bit of a pattern with this, that not all data breaches need to be reported. Data breaches only need to be reported where there is a risk to the individual. So it's a more nuanced approach, and it's an approach that requires a bit more of a judgment call. It's not an absolute requirement. So I think firstly, what I mentioned is what is a data breach, because I think this in itself is sometimes misunderstood. So data breach is effectively any wrongful, accidental loss, use, damage to personal information. So in its kind of purest form, it could be your classic sort of hacking operation, but it could be something as innocuous as leaving a laptop on the train, or even more so, and something that happens quite regularly, not least in Leathes Prior, is the occasional email to the wrong person. If it contains personal information, then it's technically a data breach. So the definition of what is a data breach is drawn very, very widely, and it encompasses all manner of things. Where there is a bit more nuance is whether or not you actually need to do anything about that data breach. So I've prepared this table which sets out the kind of reporting requirements. So under the old legislation, the Data Protection Act 1998, there was no specific requirement to report a data breach. Those have been introduced under the GDPR, but you do not need to report in each and every scenario. And we'll talk about who and when you need to report to in a second. So there's two reporting lines ultimately. Firstly, you need to report to the potentially report to the ICO, who I talked about earlier. And secondly, you might need to report to the affected individuals themselves, who in sort of GDPR jargon are referred to as the data subjects, which you'll see on that second line down. So if you suffer a data breach, as I say, the first thing you need to do is say, well, is it a data breach? And if, you know, it's one of those things, if it looks like a data breach and it feels like a data breach, because of how widely the legislation is drawn, it's probably a data breach. You then need to consider the tests in this table. So firstly, when would you need to potentially report? Well, if it's to the ICO, you need to do it within 72 hours of becoming aware of the breach, and in any event without undue delay. Most importantly, you do not need to notify the ICO. You don't need to report the data breach if there is not going to be, or if there is unlikely to be, a risk to the individual. So what that means in practice is that you need to have a look at, okay, well, what's the nature of the breach? Who's it affected? How many people has it affected? Does it relate to particularly sensitive or confidential information? Does it have information, for example, about health records or you know, political views or something along those lines, which are special categories of personal information that sort of have heightened protection? So there needs to be a bit of a fact-finding exercise and a bit of an assessment as to whether or not there's actually likely to be a risk to the individual involved. So the legislation refers to the rights and freedoms of the individual, but ultimately that just means that, you know, the privacy impact on the individual. So, for example, an email to the wrong person that has someone's name in it is unlikely, unless that email is particularly sensitive, is unlikely to be reportable under the GDPR. On the flip side, if you send out an unencrypted list of payroll records with everyone's names and salaries, potentially, you know, sickness information, that is much more likely to be a reportable breach under the GDPR, because it's much more likely to result in risk to those individuals, because everyone knows what they're getting paid, people might know what their sickness history is, and clearly someone whose motives or in their intentions were not good could potentially use that information to that person's disadvantage. So there is a bit more of a nuanced approach as to whether or not the breach needs to be reported to the ICO. So you need to look at some of those things. You know, what's the volume of data? What is the data itself? How many people are affected? All of those are going to be really, really crucial issues. The other thing you're going to want to look at is who's had access to it. You know, is the person who's had unauthorized access to it friend or foe? Are they someone who is, you know, going to do anything with that information, or are they going to sort of delete at your request that information that they shouldn't have had? All of that's going to be a consideration, but it absolutely isn't the case that any breach will require you to go off to the ICO. We then have this second reporting line, which is probably going to be even less likely, which is where you need to tell the affected individuals. You need to tell the infected individuals without undue delay. There is no specific timeline or sort of long stop date for telling them, but you will see from that exemption column that the requirement is even higher. You don't need to report if it's unlikely to result in a high risk to the individuals. Reporting to the ICO is just a risk. The affected individuals themselves are high risk. So it's probably even less likely that you need to notify the individuals. But you might want to do so as a matter of courtesy if you feel that it's kind of suitable in the situation, depending on what's happened. But the point there is that you need to carry out a little bit of a risk assessment. It doesn't need to be war and peace. It doesn't need to take hours and hours and hours, but you do need to have a little bit of a sense check around some of these points. Because remember, if you go to the ICO or if you go to the affected individuals, you potentially open yourself up to an investigation. And in that consequences box at the end, I'm not sure if everyone can see that, but if the ICO come back with more questions, then there potentially could be an investigation. You might need to give them certain reasons. As an absolute last resort, worst case scenario, there could be a fine. But as we'll talk about a little bit later on, that's very much worst case scenario. So to dispel this second myth, the requirement to report a data breach is not an absolute requirement, and it will need a little bit more thought along the lines, particularly of that exemptions box on this slide. So my third myth today, which seemed to be the most popular one from John's poll earlier, is around data protection officers, which, and you probably get a sense of all of these things. You know, I've heard a lot of incorrect information being touted around about data protection officers, and unfortunately, there are lots of organisations out there who are selling data protection officer services, whose interests it's in to promote the need to have a data protection officer. As we'll see shortly, that may not always be the case. So the myth here is that all organisations need a data protection officer. All organisations need a data protection officer, which was the sort of very much the view when the GDPR first came out in 2018. But in actual fact, and as with data breaches, it's a slightly more nuanced approach. Organisations only need to appoint a DPO in specific circumstances, and those criteria are relatively high. So a DPO needs to be appointed if, and there's going to be a big caveat at the end of this, if you are a public body or authority. But there's going to be a big caveat around this point momentarily. So if you're a local authority, public body authority, then you need a DPO under the legislation. Or you are an organisation that uses sensitive personal data on a large scale. So sensitive personal data is data that relates to things like political views, health, medical records, information around ethnicity, information around things like sexuality. All of those take on a heightened meaning. They are referred to as either sensitive personal data or special categories of personal data. And you need to be doing that on a large scale. So a really good example of this is perhaps a private occupational health provider who's going to be using lots and lots of sensitive personal data. They're currently going to do it on a large scale in sort of true lawyerly fashion. The definition of large scale is sort of massively wishy-washy and not particularly well defined, but it's just a kind of a bit of a common sense call, that one. But I would be surprised if that second category applies to lots of organisations on this call. And then thirdly, you might need a DPO if you monitor public areas on a large scale. So that could be, for example, a shopping centre has lots and lots of CCTV cameras. It could be an online digital marketing agency who use lots of information or monitor lots of information online and sort of track people's movement online. Again, I'd be surprised if that was something that applied to lots of those on the call. But the most important point here, without a doubt, is this one, which is that parish councils do not need or are not considered public bodies under the UK GDPR, and therefore do not, unless they fall into categories 2 or 3 on that slide, do not need a data protection officer. That is actually baked in the legislation itself, so it's very, very clear on this one. And I did a straw poll. I did a straw poll before I did my talk at Scribe Fest, and I did another one before I jumped on the call with you all today. And I didn't see any of the councils joining today whose websites I looked at, but I did look at a number, about 3 or 4. And of those 3 or 4, I think 3 had appointed data protection officers. And my view was probably that they didn't need to, based on what's actually required. The other tricky situation, if you have appointed a data protection officer, is who that person is, what level of skill and expertise that person has, and what level of independence they have. And actually the bar for that is quite high. So a data protection officer, and if just to give you a bit of extra comfort, Leathes Prior as a law firm have decided, based on that criteria, not to appoint a data protection officer, which I'm absolutely delighted about, because I think I would probably be in the firing line to be that person potentially. So I'm quite pleased about that on a selfish front. But we haven't appointed one because we don't fall within any of those three categories. If we did want to appoint one, that person needs to be sufficiently experienced. They need to have a sufficient knowledge about this area of law, which is not something that certainly everyone has. But most importantly, they need to have a degree of independence. It's very difficult to appoint someone within your organisation as a DPO on the basis that the law says and all the guidance says that they need to be independent. And if there was a conflict of interest, then they would, might seem bizarre, but they would owe their duty to the ICO, not to the organisation that they're working for, which could put someone potentially in a very tricky situation. So for those reasons, normally DPO services tend to be outsourced, which comes at a cost and an additional admin burden. So if you don't need to appoint one, then don't. There's no real benefit. You can have a data compliance manager who's not bound by those statutory requirements. You can have sort of, a voluntary data protection officer, although I would suggest not calling them that. Data compliance manager, a data manager, someone like that, who oversees these things within the organisation and can help out with things like subject access requests. But appointing a formal DPO under the GDPR potentially opens up a bit of a can of worms. So unless you need one, don't appoint one, is my strongly held view. And I've probably advised, I guess, anywhere between 300 to 600 clients on this over the last couple of years. And probably only about 5 to 10 of them have actually needed DPOs under the law. So and they normally are sort of my local, so sort of district, town, city council clients would fall within that first bracket. But the myth there that I want to strongly dispel, and I think it's going to be relevant for a lot of people on this call, is that parish councils don't need to appoint DPOs unless they use sensitive personal information on a large scale, or they monitor public areas on a large scale. So, myth 4, which didn't seem to be a particularly popular one on the poll at the start, but is actually one of the ones that I come across the most in practice, which is around this concept of right to be forgotten. I get it all the time with clients. Clients write to me, they get in touch and they say, I've had so-and-so say that they've read somewhere online that they can be forgotten and that I have to delete all of their information, including employees who have left, within weeks, months. And that is often seen as this absolute right. You can write to anyone at any time and say, I want you to forget all about me. I want you to delete everything that you hold on me because that's my right under the GDPR. There's going to be a bit of a pattern here, as with the last ones. Absolutely not the case. Individuals only have the right to be forgotten in specific circumstances, and it's actually fairly rare that they will have the right to be forgotten. So, individuals can only have their data erased in a couple of different scenarios. Firstly, and this is a wider point that's just everyone sort of worth bearing in mind, which is where the information is no longer needed by the organisation. So I haven't talked about it much today, but the GDPR has these certain principles that sort of flow throughout it. One of those principles is that personal information should only be used for as long as it's actually needed. And I get a lot of people asking me, well, how long do we actually need it for? Is there any specific timescales? Is there any kind of document that gives recommendations? And unfortunately, there isn't. The ICO have not sort of put their neck out and said, this is how long we think different types of organisation will need information. So they have left it for organisations to justify whether or not they need that personal data moving forwards. And with that in mind, organisations need to consider internally how long they actually need things for. But normally, if you can justify why you need it, my advice to clients is if you can justify why you need it, then you're entitled to keep it. So for example, employee records. Normally you'll need employee records for up to 7 years because that's how far HMRC can get. They can normally go back 6 financial years plus 1 if there was ever an investigation. So normally you would say, for example, employee records can be retained for 7 years, potentially longer if there's reasons to do so. What I found is that the ICO are very reluctant to override what the organisation thinks is a justifiable reason, is a justifiable time frame. I think that the ICO take quite a soft touch view on this. So if your view is that you still need the information, then there is no right for that individual to be forgotten. Whether or not you feel that you need that information, as I say, is an internal judgment call for you based on kind of common sense, sensible reasoning. But normally it's not deleting things immediately, for example, after an employee's left or after a customer is no longer dealing with someone. That's rarely likely to be the case. Individuals have the right to be forgotten where they are relying on the basis of consent. They're relying on using the information on the basis of consent, and that consent is then withdrawn. So this links in quite nicely with my first myth around whether or not you should or shouldn't be getting consent. Yet another reason not to get consent is that because if someone gives you their consent to use their information, they are entitled at any time to withdraw that consent, and you would then need to stop using that information. So this, the most important point here is to really consider whether or not you need consent, because you could potentially be found needing to delete information that you're holding on someone where you've relied on consent. And then the final reason is that the personal information needs to be deleted under UK law. So I don't think that's going to be hugely applicable to those on the call. But I know in the for example, in the medical profession, there are specific requirements to delete certain medical records after a period of time that would override what's under the GDPR. There are a few other ancillary areas, but I think these are going to be the ones that are going to be most crucial. But ultimately, if you need the information, you haven't relied on consent to use it, and you're not required to delete it under some separate UK law, then you are entitled in most scenarios to keep it and refuse any right to be forgotten or right for that individual to have their information deleted. So that's my fourth myth. And then finally, I wanted to talk to you about fines, because this was something that scared lots and lots of people, lots and lots of headlines in the media in the run-up to this legislation being introduced. And the myth is that GDPR is all about the big fines, and that the ICO are going to go wild and start fining people left, right and centre because they have the power to do so. The reality is that in the last 3 years, very few fines have been issued by the ICO. The ICO themselves have made it very, very clear that they do not see fining as, they see fining as an absolute last resort and only reserved for the most serious of breaches. So it's true that the ICO, the Information Commissioner's Office, have quite wide-ranging powers to fine. They can fine up to 4% of global turnover or 17.5 million, whichever is higher, which sounds like sort of fairly scary numbers. But in actual fact, that's rarely been the case. The ICO have only dished out approximately 50 fines in the last 3 years. You get more than 3 years now. And where they have, it's been for the really big organisations. I'm sure you'll have seen them in the news. They're sort of, the likes of British Airways, Google, Facebook, those types. it is not, and I say this to clients all the time, it is not really public policy to start fining organisations and putting them out of business or putting them at financial distress, not least right now. I just, that cannot be public policy at the moment when lots of organisations find themselves struggling financially. So I've mentioned there that fines are the last resort, and most importantly, organisations normally have, my experience where the ICO have got involved and where they've carried out an investigation, normally the ICO give the organisation the right to remedy the issue. So that's why it's really important to have your documents in place, the suite of documents you need, which I can pick up on at the end and probably will form part of the Q&A session. Have your documents that you need in place so that you've got an ability, you've got policy documents that kind of set out the process for remedying any potential issues. But the reality is, I think this will probably chime in fairly well with everyone on this call, the ICO are a public body. They are, like lots of public bodies, struggling with resource and struggling with all of the other external issues that are going on in the world. And 9 times out of 10 will not be, actually 99 times out of 100 will not be particularly interested. Most of the reports that I make to the ICO, most of the conversations that I have with the ICO tend to sort of end with a bit of a shrug and, yeah, fine, that all sounds okay, just make sure they don't do it again sort of scenario. So if you've got the framework, if you've got the documents in place that allow you to set out a process to remedy some of these issues, the ICO are unlikely to be looking at some kind of punitive action. And I'd be very, very surprised if they're taking that line at the moment. So in terms of final thoughts, I mean, that's been a bit of a kind of a whirlwind tour on of some of the key aspects of the GDPR, and most importantly, the aspects of the GDPR that there's the most misinformation about, and that most organisations find it difficult to get sort of clear answers. So hopefully I've clearly addressed some of those issues. I think my view is that the GDPR is to perfectly comply with the GDPR is a very difficult task, and I'm not entirely convinced that there's any organisation out there that's been able to do it. What the GDPR has become is a process of putting in good practice in place, even if you are not perfectly complying with absolutely every aspect of it. Because with the GDPR, you can always improve, you can always do something more, and what you'll find is that all of your time is being swallowed up by this compliance exercise, which is not necessary and is not proportionate to the potential response that you would get. What it does is it sets out a set of good practice that you can follow. And I think with 2 or 3 steps and making sure that you get clear information on some of these things, it's perfectly doable to meet that good practice that's set. So with that, John, I think I'll pass over for a bit of a Q&A session.
Cool. If you'd like to unshare your screen there, Alex, thanks a lot for your myth busting. So, data protection practices and regulations do seem scary and overwhelming, but really they're just in place to request or maybe sometimes demand organizations have good controls in place for managing their digital data, in particular personal data. And often we think about ourselves as just a single user working on our own on a single laptop or PC, but in reality, in local government, we've got multiple users of data. We've got clerks, councillors, auditors, and sometimes even the general public. So, and all these people have different devices, laptops, PCs, iPads, phones, etc., may store data locally, may store it in the cloud. And often for clerks and councillors and auditors to do work, data is copied and shared around, particularly spreadsheets are quite common with that. So data can be scattered everywhere. So they can be in folders on your local PC or in the cloud. They can be in email boxes, and really, you often don't know where data is, and there's many different versions of truth. So if you find you're in this situation where you are having to copy data all around all the time to get your work done, then you've got to think about these regulations. Like if you do need to understand the consent status of individuals, personal data in that you store, and how you're going to manage right to be forgotten. Where is that data? Can you track it? Freedom of information requests and data breaches. You should ask yourself, are you able to be scrutinized about that? And we try and, at Scribe, we are trying to remove that fear of making that mistake. I mean, one of the key things we do is allowing multiple users to access our software from anywhere. So you don't have to move data around and copy it. We have a single source of truth for that data. And most importantly, we have really robust audit trails in place. So if an auditor does log on, you'll know that happened. You'll know, all changes to all the data, what the state was before and after, really detailed audit trails, and then also data is all hosted and backed up every day. So if you want to know more about how we can help you with this and take this fear out of managing data, particularly personal data, just drop a yes and you can have a 15-minute chat with one of our experts. So we'll go straight into questions. I've got a couple of questions already raised. This is from Jane Purcell, and she says, is an address part of GDPR, but when the address does not contain a name?
Yes. Yes, it is. And that's been really, really clear, because it will identify a living individual or living individuals by reference to a bit of information. So it's a sort of tried and tested status that yes, addresses would, as long as they relate to someone who is alive, they would fall within the remit of the GDPR.
But if there's no name attached to it, then?
Well, because you could still identify the individuals living at that address.
Okay, all right, cool.
Yeah, so that's normally why.
Juliet Koprowska, I hope I pronounced that correctly.
Koprowska.
Oh, you can ask your question, Juliet.
Okay, yeah, at the beginning you said that there were six types of alternative to consent, but you only mentioned 3 of them, or 5. There were 5 alternatives, you only mentioned 3. So what were the other 2?
I did, yeah, and the reason that I did that is because they're probably unlikely to apply here. So the 2 others are where you need that person's information to effectively save someone's life or prevent them from serious ill health. Mm-hmm. And the other is where you need to comply with a legal obligation. But for most of those on the call, I suspect that is going to be picked up rather by the public task requirement. So if there is some separate legal requirement, it doesn't involve your operation as a public body, then you would be entitled to rely on that as well.
Okay, thank you.
We've got a question from Robin. Robin, you can ask it or I'll shout it out. I'll shout it out. So Robin is asking if a councillor, unpaid councillor, or any employee within the parish is using their personal email to conduct business, what is the position in law? Yeah,
it's a good question. If they
was it Hillary Clinton? This is what she did, wasn't it? Yeah, she was using her personal email for a lot. Yeah.
She was, yeah, she was. Slightly different scenario, but we come across it quite a lot. If someone is doing things with personal data that relates to their employment or their volunteer duties, then they are effectively processing that information on behalf of their organisation, and therefore everything that they do with that information falls to the organisation to ensure that it's being done in a way that is compliant with the UK GDPR. So all of these rules that I've talked about will apply. I suspect the biggest concerns there are going to be around data security, and in the event of a subject access request, being able to sort of recover that information and show it. So a volunteer, an employee using their personal email address is not per se a breach of the UK GDPR, but it does bring into question whether or not the UK GDPR is being complied with. So what we do certainly at Leathes Prior, and what a lot of clients will do is sort of ban processing on individuals' own personal devices. Alternatively, what you can do is put a short form policy in place to say where you are using council information on a personal device, you need to ensure that you are complying with the GDPR, make it very, very clear that the GDPR still applies to that activity. And if there are other policy documents that you have in-house, make sure that those also apply as well. Because then at the very least, in terms of mitigation, you can say, well, look, we're a parish council. We're not in a position where our budget extends to getting brand new iPhones for everyone that are owned by the council. And I think that's a completely understandable argument. But you need to make sure that you have communicated to all of the individuals who are using what is effectively council data, that they are doing so under the remit of the GDPR, and they're being bound by the rules of the GDPR and the council's own policies. That's going to be really, really crucial if you ever needed to defend your position later on. Ideally, as a starting point, it wouldn't happen. If it does happen, if it has to happen as a matter of an operational requirement, day-to-day requirement, because you can't afford to get own devices and someone needs to use their personal email, then take those mitigating steps to make sure that you're still within the realms of the GDPR. And if you do that, then you're still going to be in a fairly good place if you ever needed to defend it.
Got a question from Siobhan Burton. I might be able to have a crack at this one. So she's a newish clerk, has no filing system in place for data recording. So how does one conduct a freedom of information search, and how long does it take? So as far as I know, a freedom of information search, if it's a small one, then you have 1 month. If it's a simple one, you have one month to respond to it. So that's basic, like if you have a personnel document and it's very easy to get. But if data is if it's a complex one and data is in different systems, you've got 3 months to respond. But this goes again back to my point, if you don't have good tools in place for managing data, it's super hard to do it. It's not about how it will take you ages to do. You think about the simple act of you're sharing account information in a spreadsheet, and that spreadsheet has customer data information in it, has their phone numbers, their addresses, etc. in there. You share that financial information with your counsellors, maybe there's 7 of them, in email, and then they might leave it in the email, they might download it, they might be on their phone, so that just makes it much harder to respond to one of these requests if you're having to copy all your data around. So again, if you want to know more about that, feel free to drop yes in and we can chase up with you. Another one about email. This is a good one. Yes. Hi,
John. Sorry to interrupt there. I was just going to say, are you happy for me to just quickly build on that response?
Yes, for sure. Yeah.
Quite useful. Because there's a little bit, another area of confusion is around Freedom of Information Act requests and subject access requests. So Freedom of Information Act requests apply to all data, whether it's personal data or not. And it's a reporting or a disclosure requirement that applies really only to public bodies, public authorities, or kind of quasi-public authorities. And the requirement to respond, the ability to sort of bat away a Freedom of Information Act request is much, much easier. There are lots more exemptions than there are for a subject access request. So the first port of call would always be, well, what are we dealing with here? Are we dealing with a subject access request under the GDPR? Or are we dealing with a Freedom of Information Act request under separate legislation from 2000? And if it's relating only to personal data, then it's always going to be a subject access request, because the Freedom of Information Act request doesn't actually apply to personal data. And that's one of the exemptions. So if it's covered by, it's a subject access request. And as you rightly say, John, a subject access request is a month to respond initially, but you can extend that for a further 2 months if it's complicated or if there are other circumstances which mean that you can't respond. And I advised a client yesterday, in fact, on this very point, which is that because of Christmas and because lots of offices are going to be shutting down, that might be a reason that you would extend a subject access request. So it's really, really important to categorize what you're actually dealing with. If it's a Freedom of Information Act request, then there are different timescales that actually apply. So it's 20 working days, or if there's a public interest test, which is sort of going off into a whole new area, which we probably won't have time to talk about today, then it's 40 business days, 40 working days. So there are two different reporting timescales. But if someone gets in touch and says, I want you to give me all of the personal information that you hold on me, that's a subject access request. If it's an individual, or for example, a media outlet, who are often the ones who make these Freedom of Information Act requests, then that's something separate, but it's going to be easier to bat away. A subject access request for an individual is quite difficult to push back on. So I just wanted to be from the off kind of clear
yeah,
about
good. Thanks, Alex.
two different things.
Cool. So the final question, we should be wrapping up soon because we're already over schedule. Catherine Boyce, she has a good one here. So if you receive an email inquiry to the parish and you can't deal with it and you need to send it on to district or county council, do you need consent to forward that?
No, I mean, it's a really, really good question, and sort of touches on a few things that I've talked about today. So if someone gets in touch with you and says there's an inquiry or something that you can't deal with, then as long as that thing wasn't sort of ultra sensitive, or there wasn't some kind of sort of huge privacy impact that was going to apply to the individual, then you would have a legitimate interest to, when passing on to the right authority, to the right body, because clearly it would be entirely impractical and just a real pain to sort of email back and say, can I have your consent? Because if you think about it, to email back, to respond to the initial email, you would have needed consent at that point rather than afterwards, because you're then using someone's personal information. So in those circumstances, you would be able to rely on having a legitimate interest, unless, for example, that person said, I don't want you to forward this on to anyone else, or that person was sort of sharing something that was very, very sensitive or very, very difficult. You might at that point want to go back, not necessarily even as a matter of law, but just as a matter of good practice, and say, you're happy for me to pass this on. But I suspect in most scenarios, you will have a legitimate interest that will outweigh the privacy impact on the individual. And I suspect from the individual's perspective, if they've got an issue that they want dealt with and you're not the right person to deal with it, they probably would want you to pass it on anyway, wouldn't you? I think there would be a reasonable expectation it would find itself, in the right inbox from an individual, and they might sort of react negatively if you turn around and say, okay, well, can I get your consent to do this? And you get them to, to fill something out or complete some kind of tick box exercise. I suspect in almost all scenarios, that's just not necessary.
Cool. Thank you so much, Alex. I know you've had a really hectic morning this morning dealing with the latest COVID issues, so really appreciate you coming along to talk to us again. So we should all wave and say thanks to Alex. Really appreciate all coming along again. So this is actually our last Scribe Academy event of the year, so wish you all happy Christmas. If you want, we've got a whole bunch more planned next year. These are free events, then available to anyone. So if you go along to scribeaccounts.com, you click on Scribe Academy after support, and then come down here. You can go on the open to everybody, and then this is Alex's talk here, and then we've got a few more lined up for the new year, all focused on accounting and year end. Feel free to go along and sign up. Otherwise, yeah, have a really good Christmas.
Can I just say, I've got one booked in for tomorrow.
Yeah, that will be, that's a customer one.
Oh, okay. Phew.
Yeah, so we have custom ones, but we also do these free ones.
Oh, okay.
Anybody. Yes.
Okay.
Cool. All right. Have a good one. Cheers.
Thank you.
Bye.
Thanks very much.